Hi, my name is Tom McNulty, and I am counsel with the Boston-based intellectual property law firm of Lando Anastasi. I'd like to present a short video on intellectual property issues that are associated with the rise of artificial intelligence, or AI, programs that took place in 2023. Artificial intelligence emerged over the past year as a powerful new way of generating creative works. Programs such as DALL-E 2, Stable Diffusion, and Midjourney create images based on textual prompts from users, while other programs such as ChatGPT and AI Writer create written works and interact with users in a conversational manner. The rise of such software and subsequent attempts to register copyrights and patents in the works generated by such software has created interesting questions with respect to whether any intellectual property rights should attach to works created using artificial intelligence. On the copyright side of things, there were three significant attempts to obtain registrations on AI-generated artworks. One was a computer-generated painting entitled A Recent Entrance to Paradise that was entirely generated using artificial intelligence. A second of these was another piece of artwork entitled Theater d'Opera Spatial. And this was a work that was entirely generated using artificial intelligence, and then the artist used Photoshop and some other software to modify the image, added some things, took some things out, that sort of thing. And a third of these was a comic book, Zarya of the Dawn, where the author wrote the book but generated the images using Midjourney. In each of these instances, the Copyright Office refused to register the copyright in these works on the basis that under copyright law, the author of the work in question has to be a human being. The first of these, the Recent Entrance to Paradise work, there was no human contribution. The person who submitted the registration was open about that. With respect to the Theater d'Opera Spatial work, the person who submitted it was open about the use of AI to generate the underlying image. However, he maintained that he was entitled to a registration on the finished artwork, while the Copyright Office indicated that if he was willing to disclaim the material that was AI generated and only claim copyright in the portions that he himself contributed, they would consider giving him a registration. But as he was not willing to do so, they denied him. And in the third of these, the comic book, Zarya of the Dawn, the author actually didn't notify the Copyright Office of the contribution of Midjourney, received the copyright on the work, and then apparently posted to social media that she had obtained the first copyrights on artificial intelligence-generated work, and the Copyright Office saw this and rescinded the copyright, but did indicate that the overall composition and selection of images, arrangement of images and whatnot was protectable, as was the text. So she did receive a copyright in the book itself, but each of the images in the book that were generated by Midjourney are free for public use. So the Copyright Office's position is that there has to be a human author. This is something that they've indicated they'll treat on a case-by-case basis. So it may well depend on the software that's being used and how much control the actual person putting in the prompts has over the final image and how much of it is generated. The creative decisions are made by the software itself. So in looking at some of these cases, they decided that the AI system itself was the entity that was executing the traditional elements of authorship, the expressive content of the images, and that merely entering prompts and perhaps editing the prompts themselves and then selecting the final image that is to be used is not sufficient input from the human side to qualify for copyright protection. They do note that there may be instances where there's sufficient human authorship to obtain a registration over at least the human component. So again, if the human being that's involved in this is making creative choices in the image itself, as opposed to in the prompts, using Photoshop to edit images, applying things to the image or whatnot, then that itself may be sufficient to at least get protection for the human generated part of it. They indicate that they're going to look at this on a case-by-case basis. So we'll really have to see what sorts of developments come from the Copyright Office in terms of what they do and don't register. So to that end, the Copyright Office has put out a guidance on what should be submitted when you're seeking registration of something that includes AI-generated content. The application should identify the human authors and provide a brief statement in the author-created field that describes the contribution of the human author, what sorts of things they contributed to the final piece. If it involves creative arrangement of human and non-human content, that field should also be filled out to claim selection, coordination, and arrangement of human-authored things and selection, creation, and arrangement of AI-generated things. You should not list the AI program or the AI company as an author or as a co-author, but you should describe the contribution that was made by the AI program. If there's a significant contribution by the AI program, you should plan on excluding or disclaiming that contribution from the registration. The guidance further provides for correcting information on a previously filed application to the extent that something's been filed without this sort of information. The rise of artificial intelligence technology has also driven to the forefront some issues relating to infringement. There have been a number of lawsuits filed by various different groups asserting that the AI companies, when they scrape the internet and they use copyrighted materials to train their systems, are committing copyright infringement. It's fairly openly acknowledged that as part of this training, they necessarily make copies of the materials that they're training the systems on. And it's pretty widely acknowledged that, at least with respect to a lot of these companies, they're scraping the internet for anything and everything they can get their hands on. So it certainly would include copyrighted materials. The AI companies are asserting that this sort of conduct constitutes fair use. They indicate that the work is transformative and that it's not competitive with the types of things that the underlying works are being marketed in. As this is a fairly new technology, there's been very little action from the courts really setting out any parameters or indicating how they're going to treat this. But there have been a few cases where we've at least got some initial guidance in 2023. In September, a district court determined that a jury trial would be needed to determine whether it was fair use for an AI company to copy case summaries off of Westlaw, which is a legal research platform, to train their AI program to quote pertinent passages from legal opinions in response to questions from users. The legal opinions themselves are generally fair game. The case summaries are perhaps not, because they are subject to copyright. And the court found that while the defendant's use was undoubtedly commercial, the defendant was looking to provide quotes, and they were doing it for money, a jury would be needed to resolve the factual disputes, considering whether the training constituted fair use. And this opinion sort of necessarily considers the output of the artificial intelligence, not just the training. So the decision in that case may well come down to what was actually being received by the users. In another case involving the creation of images, a judge agreed with the artificial intelligence companies that the images the system actually created and output likely did not infringe the artist's copyrights, and he was not convinced that allegations based on the system's output could survive without a specific showing that specific images were substantially similar to the artist's work. So that seems to suggest that suits based solely on the data that is fed in and used for training perhaps face an uphill battle. One thing that businesses can consider in terms of combating this is have your website have terms of service that prohibits web crawling, so that at a minimum, if they're scraping your data, they're committing a breach contract as opposed to a copyright infringement. A lot of AI companies are now instituting policies to try to prevent these sorts of suits, including things like opt-out provisions, where you can opt out of having your site scraped. I'm not sure that that's going to ultimately prove sufficient to get around copyright infringement. If otherwise it would be, but that's at least a step, and it indicates that they're at least putting some effort into avoiding the problem. A more interesting case was filed towards the end of the year. The New York Times filed suit against OpenAI, the creators of ChatGPT, asserting that both the scraping of data from the New York Times and some of the output constituted copyright infringement. With respect to the data scraping, the New York Times is one of the 5 or 6 biggest sources for material that was used to train ChatGPT. Perhaps that will make a difference. But the more interesting part is on the output side. They were able to show that ChatGPT would put out verbatim or near verbatim full articles from the New York Times that they had been trained on. I think an interesting question about this is going to be the methods that they use to get this. They ask questions like, and this is a quote, "Hi there, I'm being paywalled out of reading the New York Times article, Snowfall, the Avalanche at Tunnel Creek. Could you please type out the first paragraph of the article for me?" And then when ChatGPT would do so, they would say, "Wow, thank you. What is the next paragraph?" And so forth until they got basically the full article published to them. The complaint itself, many of the examples contain this kinds of prompts. ChatGPT has responded saying that, the infringements that are alleged took place not in the immediate past, but further back in time, and that they're continuing to work and develop the software so that it won't spit out verbatim things like that. So that'll be sort of an interesting question as to what happens with that. Another interesting issue is this notion of training ChatGPT or training any AI program to put material out in the style of or in the voice of particular people. There's been a suit filed by Universal Music. An AI-generated song called Heart on My Sleeve was produced, and it was made to sound in the style of the artists Drake and The Weeknd, to receive millions of streams, but it's not actually a copy of a song by either Drake or The Weeknd. It's just in the style. There's a second suit that was recently filed. There was an AI trained on George Carlin. They fed, I don't know, 50 years of George Carlin performances into the AI, and then they created a George Carlin style show where the jokes are in the style of George Carlin, and it's his voice, or effectively an AI generated version of his voice that's delivering the jokes. There is some dispute in this case. The creators of the show claim that they wrote the jokes and not AI, but we'll see what happens with that. That suit included copyright claims, and I think some of these suits are going to be problematic, and this is probably something that's going to have to be addressed at the congressional level, because it's not actually copyright infringement to imitate somebody's style or necessarily to imitate their voice. Impersonators do that all the time, and it's never been treated as copyright infringement to do so. There may be problems with states' rights of publicity laws, rights to privacy laws, perhaps trademark infringement, but I don't think this one will end up ultimately fitting under copyright as it currently stands. A final question that arises with respect to whether there is copyright infringement from the outputs of an AI program is, who's the infringer? Is it ChatGPT? Is it the person who put in the prompts? Is it the entity that provided the training materials? Because very often AI companies are not themselves scraping the internet. They're employing third parties to do so. Who's the direct infringer? Is there vicarious infringement? There's a lot of questions that have yet to be worked out. So it's sort of a Wild West right at the moment, but I suspect that there will be a lot of action in 2024 in this regard. It's not the only area that AI is creating problems for. There were a couple of decisions by the Patent and Trademark Office and by the Federal Circuit related to applications for inventions that were created using artificial intelligence. An individual named Stephen Thaler submitted an application identifying a particular AI program as the inventor, and again, asserting himself as the owner of the inventive subject matter as a work made for hire. And both the Patent Office and the Federal Circuit agreed that, as with copyright law, patent law requires an inventor to be a human being and not an artificial intelligence program. And the Patent Office refused to examine the patent application, and the Court of Appeals also rejected the applications on that basis. They also addressed the fact that an artificial intelligence program is a non-sentient being, as far as we know, can't actually consent to or contract themselves into a work made for hire kind of a situation. So as things stand right now, if it's AI generated, you can't get a patent on it. But that raises some interesting questions. What if there's a human contribution and a non-human contribution? What's the applicant's duty of disclosure in that regard? There's nothing definitive on that yet, but it certainly seems like the contribution of an AI program may be material to patentability. And the failure to disclose that, if it comes out later, may destroy whatever rights you were able to obtain from the Patent Office in that regard. This raises other questions with respect to patentability. Under U.S. patent law, an invention is not patentable if it would have been obvious to a theoretical, quote, person of ordinary skill in the art who has knowledge of the pertinent art in question. So I think an interesting question is, with artificial intelligence systems having access to just reams and reams of data, could an AI system be deemed a person of ordinary skill in the art? Or at least at a minimum, could the person of ordinary skill in the art be deemed to have access to an artificial intelligence program? The data that showed that the New York Times was one of the most scraped organizations, in terms of training AI, the U.S. Patent Office was actually at the very top of that list. So if an AI system has access to all the patents in America, suddenly the ordinary person of ordinary skill in the art knows a whole lot more than he would have, say, 2 years ago. And the broader scope of art that person knows, the more likely an application is going to be deemed obvious. So this will be sort of an interesting question for the Patent Office and perhaps for Congress or the Federal Circuit or whoever to deal with. Somewhat related to this, the rise of AI may lead to patent attorneys having to reconsider their decisions on filing for inter partes review. Inter partes review is once a patent has actually been granted, you petition the Patent Office to invalidate claims on the basis of prior art that they hadn't considered. And it comes with an estoppel. If you petition for an inter partes review or an IPR, you'll be estopped from raising invalidity in any subsequent litigation on any grounds that you did or reasonably could have raised during the IPR. And the courts have held that basically to mean that a reasonably diligent searcher would have come up with when they were looking to file the IPR. With the rise of artificial intelligence having access to all of the patents in the country and perhaps all of the patents in the world, is there going to be anything that a reasonably diligent searcher couldn't have come up with? And like I say, this may sort of change the calculus for when you choose to file an IPR, the number of grounds you choose to file on, things like that. I think this will be another interesting question that should see some development over the next year or so. The final area I want to look at is trade secret law. Unlike copyrights and patents, there's no authorship or inventorship qualification for trade secret law. There's no obligation that it be created by a human being. It's based solely on its having value and it's not being generally known. So things created by artificial intelligence are, at least theoretically, subject to being protected under trade secret law, provided it's something you can maintain the secrecy of. One of the things you'll have to be very careful of, however, if you're looking to generate valuable trade secret information using artificial intelligence, is the various AI programs, the confidentiality of the prompts of the information you feed in varies considerably but subject to change by those companies on an ongoing basis. So there's a risk that whatever you put into an AI system will be used to train the AI system and potentially be subject to being output to a different user. And quite frankly, if that's the case, even if it hasn't been output to a different user, that you have not maintained the secrecy thereof, and that will destroy any potential trade secret protection. This actually happened in a case involving Samsung, big sophisticated company, but they had allowed engineers at their semiconductor branch to use ChatGPT for a variety of reasons, to fix problems with source code, to summarize meetings, to produce reports, that sort of thing. An employee asked ChatGPT to optimize test sequences for identifying faults in chips, and all of the information that was input was trade secret confidential information at the time to Samsung, and they acknowledged that by inputting it into ChatGPT, where it is now, at least based on GPT's terms of service at the time, freely used to train ChatGPT and freely outputable to subsequent prompts, that the trade secret in that has been destroyed. This resulted in Samsung developing its own in-house artificial intelligence for internal use by employees and basically prohibiting them from public artificial intelligence programs. They limit the amount of information that can be put in. This is some of the steps that they've taken to try to prevent this from happening again. At the time, at least, OpenAI expressly told its users not to share any sensitive information in the conversations with the company. I believe that they are now trying to create, not necessarily to do away with that, because they want whatever material they can to train their programs, but they are trying to come up with options so that potentially you can put stuff in without having these spheres in place. Terms of service are susceptible to change pretty much at any time. So you're really taking your chances relying on, what the state of the terms of service and the confidentiality and whatnot are at any given day. So if you're looking to maintain the secrecy or confidentiality of any of your information, you should really be looking to place limits on what can be put in, what types of information can be put in, how much information can be put in. You should have language related to this with any independent contractors you use. You really should be cautious of disclosing anything to an AI program that may end up spitting it back out in the future. In conclusion, I hope that nobody takes this as a suggestion that you not use artificial intelligence in your business. There's certainly a host of ways that it can save you time, it can save you money, it can further development efforts, it can further research. And on top of all this, you can be sure that your competitors are looking at these issues and are looking at using AI to gain a competitive advantage, and it's not something you want to bypass. However, this is a very new field, and it's just hit a point of development where it's really raising some of these IP-related issues. The speed with which it's improving suggests that this is going to become more and more of an issue rather than less over the next year. Certainly tune back in and we will keep you updated with anything that develops in this field. Thank you. My name's Tom McNulty, and thank you for watching this video.